Now we've decided that you're going to seek out some information prior to hiring a lawyer. You're not just going to hire somebody based on their marketing. So, what are you looking for? Well, first off, I suggest that you hire an attorney who's proven to be competent in the area of law that you're going to be engaged in. Now, what the heck does that mean? You want someone who's handled a case like yours before, but you don't want someone who handles a couple hundred cases like yours at any given time. You want to check, you want to ask them point blank, how many open cases like mine do you have right now? How many attorneys do you have right now? Do you have a maximum caseload per attorney per paralegal? If they can't answer those questions, you need to think about running. An attorney needs to know, a law firm needs to know how many open cases they have at any one given time. It's just a matter of responsibility. If the lawyer tells you that they have more than 50 or 60 per attorney cases like yours at any given time, the next question you need to ask is, how do you intend to give my case the attention that it deserves? And listen to the attorney's answer. If it makes sense, great. If it doesn't, you may need to think about running. The next thing you need to think about is, what is your track record with cases like mine? Do most of your cases settle, or are they tried? Now, that's a double-edged sword, whether it's settled or tried. I'll tell you, based on, in the last 10 years, I couldn't tell you. It could be 2,000, could be 5,000. I don't know how many thousands of cases that we've seen all the way through. Very few of those go to trial. And I'm not ashamed of that. The reason they don't go to trial is because we're prepared on the front end. Most trials happen when there is a failure of communication between the two parties. When the plaintiff has not done their job, they have not put together their evidence properly, they have not properly documented all the injuries, they've not properly documented how the incident happened, or they've not clearly communicated their position to the opposing side. Or it could just be that someone's being completely unrealistic. That happens, and we'll talk about realistic expectations and what that means. From the defense side, reasons things go to trial. Again, it's failure of communication. It is a failure of the defense lawyer to properly identify what's going on in the case and to get their evidence together and then communicate that to the powers that have the checkbook. Or it may just be unrealistic expectations from the defense side. All we can do is make sure that everybody's drinking out of the same well. If everybody has the same information, assuming you have reasonable people, you should be able to come to some sort of agreement. But at the end of the day, it's not the lawyer's decision whether or not to go to trial. If the client says, I will not accept that, or if the insurer on the other side says, I will not pay that under no circumstances, then you have no choice but to go to trial and put the value or outcome of your case into the hands of a jury. It doesn't happen very often. You have lawyers who like to market the big bad insurance company, the big bad insurance company. Insurance companies are businesses. They have no emotional connection to this whatsoever. It's dollars and cents to them, and at the root, what they're doing is assessing risk. They say, based on these facts, based on this law, we assess our risk level to be X. Given this risk level, we're willing to pay Y to mitigate that risk. It's as simple as that. The plaintiff's attorney, their job is to increase the risk. The defense attorney's job is to identify the risk, first off, and then mitigate that risk. That's the whole chess match going back and forth. Increasing risk, identifying and mitigating risk. And that's why you see a lot of defense attorneys who are do very well as plaintiff's attorneys, because they're trained and have experience identifying that risk. They know how to mitigate it. Therefore, they know how to prevent that mitigation or at least deflate the mitigation of the risk. Anyways, so identifying the risk, gauging the risk, that's what insurance companies are doing. They're not taking flatly unreasonable positions because they just don't like you or because they just don't like your case. They're taking positions which you believe to be unreasonable because your attorney has not properly identified and increased the risk level. That's what's going on. Now, on the plaintiff side, a little different. Plaintiffs live it. It's personal to them, and I completely understand that. And that needs to be communicated to the insurance company and the defense lawyer. It needs to be communicated not only that it's personal, but how it has impacted your life personally. What you do by doing that is you take away this, hey, this is personal to me, I'm owed more. And by clearly communicating how it has impacted your life, you take it out of that subjective minutia, I hate to say, is what the insurance company is going to look at it as. Oh, they just want more money. And you use it as a way to increase the risk, thereby increasing the value of your case. So it's all in, like my wife says all the time, Beau, it's not what you say, it's how you package it. So it's packaging. It's how you communicate it. More often than not, 99.9% of the time, case is not going to go to trial. It doesn't need to go to trial. The only times I think that a trial is warranted from the plaintiff side is if you've got what I call a free swing. If for whatever reason there's plenty of coverage, there's unlimited coverage, whatever it may be, and there's no top end to gauge it against. So let me back up and explain this. All this negotiation, all this risk assessment has to go on against the backdrop of the limits of coverage. So say there's $100,000 worth of coverage or $1 million worth of coverage, whatever it may be. And also assume that the defendant has no personal assets. Let's put those aside because that rarely happens. You have to understand that on your best day as a plaintiff, the most you're going to get is X. You know that number, okay? In a situation to where that number doesn't matter, meaning that your case is meaning that there's so much coverage that it's unlikely that your case will eclipse that. So let's say you have a case that's worth $100,000 reasonably, but you know that there's $1 million of coverage on the other side. Well, in that scenario, it may be worth it to the plaintiff to roll the dice and see what a jury comes back with. If you assess the case as, hey, I think on our worst day, the jury may give us $60,000, but on the best day, they may give us $500,000. Looking at those numbers, it might make sense for the plaintiff to actually go forward with the trial. And similar to the plaintiff, the defense knows this. The defense should be having that exact same conversation. Hey, you might want to pay more in this scenario because it's a no-lose. It's a free swing or free roll for the plaintiff. What they stand to lose is a lot less than what they stand to gain. So outside of those scenarios, trials are because people don't do their job.